I'm ready when all right, thank you. Can we get the competitors on screen just to make sure that we're ready to go? See there? Okay, great. Excellent. Okay, thank you very much. Then with that, let's call the case. So we're calling the case of Ethel Marks versus Sonny's Rooftop Bar to order. Let's start with appearances from both parties, beginning with the plaintiff.
Good morning, Your Honor. My name is Sammy Morris-Beber, and I will be representing the plaintiff, Ethel Marks, in today's case. And serving as my second chair is Maya Musselman.
Thank you, counsel. Defense?
Good morning, Your Honor. My name is Catherine Hunnicutt. Today I'm representing the defendant, Sonny's Rooftop Bar, and I'm joined today by my second chair, Peyton Robertson.
Good afternoon, Your Honor.
Good afternoon. Thank you, defense counsel. All right, back to you, plaintiff. Any preliminary matters you want to take care of before we go to opening statements?
Yes, Your Honor. First off, Your Honor, we request your preferences as to screen sharing exhibits.
Yes, so let's just assume for efficiency's sake, you can show it on the screen to get the witness to identify it, and it will be constructively outside the presence of the jury until it's admitted into evidence.
Yes, Your Honor. And secondly, we would like to inform the court that exhibits 1, 22, and 23 are pre-admitted and already in the record.
That's my understanding of the pretrial order. Defense, do you have any, is that a correct characterization to your understanding?
Yes, Your Honor.
All right, great. Noted. Thank you, counsel.
No further preliminary matters from the plaintiff, Your Honor.
All right, thank you. Defense?
Yes, Your Honor. I just have one preliminary matter.
Sure.
So as it pertains to screen sharing exhibits, would you like for us to ask permission before doing so, or simply announce and ask to let the record reflect that we are doing so?
Yeah, the latter. So no need to ask permission explicitly. You can just state for the record that you are doing it, and then we'll assume that no one sees it except for the witness. And then when it's admitted, it's constructively published to the jury. So you don't need to ask to do that either.
Yes, Your Honor.
All right, great. Anything else?
Not at this time, Your Honor.
All right, sounds good. Thank you very much, both parties. Then with that, let's proceed to opening statements. Am I saying this right? Ms. Morris-Beber or Beber?
Morris-Beber, Your Honor.
All right, thank you very much. You can proceed whenever you're ready.
Thank you. Sonny's Rooftop Bar had the responsibility, so now they must face the consequences. It's spring break, the night of March 24th, 2019, and business is slow at Sonny's Bar. So it's just Sonny Mehta and Frankfurt Johnson working. And two girls walk in. They order wine, beer, hard seltzer, and shots until one of them, Jessica Marks, is drunk. Then she walks out into the night. She drives her car. She makes it 1,000 feet before she veers across the highway and crashes into a ravine to her death. That night, Sonny Mehta had one clear responsibility: stop serving an intoxicated person. And the consequences of her failure in that responsibility was the death of 19-year-old Jessica Marks. The plaintiff will show that Sonny's Rooftop Bar is liable for Jessica Marks's car crash and death under the Dram Shop Act. We must prove by preponderance of the evidence, or more likely than not, that the bar and its employees served alcohol to an obviously intoxicated minor, and that over-serving was a substantial factor in the crash. So let's break that down a little bit. Because it's undisputed that Sonny's Rooftop Bar served Jessica Marks alcohol. It's undisputed that Jessica Marks was underage at the time she was served alcohol. And the law does not require Sunny's rooftop bar to have been aware that she was underage. So all the plaintiff has to prove is two things. First, that Jessica Marks was served when she was obviously intoxicated. And second, that over-serving by Sunny's rooftop bar was a substantial factor in her car crash. So let's talk about that first element, obvious intoxication. We'll hear that phrase a fair amount today, and all it means is that a reasonable person would perceive Jessica Marks was drunk. And to prove Ms. Marks was obviously intoxicated, we will hear the testimony of Morgan Levin, Ms. Marks's best friend who was with her that night. Ms. Levin will testify that her friend slurred her words, had bloodshot eyes, even stumbled into Sunny Mehta. We will see a video of Ms. Marks taken around 11 p.m. showing she was rambling. You will hear the bar kept serving her. They served her to the point that Ms. Marks was too drunk to drive. And we will make it clear they should have realized that. Finally, the plaintiff will prove the bar's furnishing of alcohol was a substantial factor in Ms. Marks's car crash. We'll have a chance to see Ms. Levin's receipt, which shows Ms. Marks ordered 5 drinks and a bottle of wine from Sunny's bar. We will even hear Sunny Mehta admit Jessica Marks's blood alcohol content was 0.16. Twice the legal limit for an adult, and certainly high enough to have caused that crash. That night, Sunny Mehta had the responsibility. So now they must face the consequences. And at the end of today's case, I will ask that you find Sunny's rooftop bar liable for Jessica Marks's car crash and death. Thank you.
Thank you very much, counsel. Defense?
Yes, Your Honor. Permission to proceed?
Yes, whenever you're ready, go ahead.
Who called the shots? There's a scene you didn't hear about from Miss Morris-Beber. It's 11:45 p.m. and Jessica Marks is at her car. She's been drinking. She knows it's dangerous to drive, but she makes the conscious choice to get in her car, turn the key, start the engine, and drive away. With all due respect to Miss Morris-Beber, the real question we need to ask ourselves here is who called the shots? Good morning. My name is Catherine Hunnicutt, and today I represent the defendant, Sunny's Rooftop Bar. Now, in talking about what this case is, it's important to understand what it's not. It's easy to be misled by my opposing counsel, but the plaintiff's claim is not what's commonly known as a negligence case. Their claim is not about whether Sunny's Rooftop Bar should have done more to prevent Miss Marks from driving away that night. It's not even about whether or not Miss Marks was obviously intoxicated at the time she left the bar. No, this case is much narrower. And if we take a look at the Dram Shop Act here, you'll see that the things that the plaintiff have to prove, well, it only leaves us with 2 questions. 1, was Jessica Marks obviously intoxicated at the time she was served? And 2, did the actions of Sunny's Rooftop Bar proximately cause the plaintiff's death? And now today, we as the defense have asserted an affirmative defense of comparative negligence. What that means is that we've taken on a burden, and we're going to ask you to take a look at Jessica Marks's own actions. Look at her actions and ask yourself, who called the shots? Now, my opposing counsel talked a lot about Sunny Mehta, and fortunately, you'll get a chance to meet her yourself. And the evidence will show that while Sunny did serve Miss Marks's table, every time Sunny brought a drink to their table, Miss Marks wasn't showing signs of obvious impairment. Tipsy? Yes. but not enough to rise to the high threshold of obvious impairment. Which brings us to Miss Marks. And as tragic as the circumstances are surrounding the death of Jessica Marks, and my heart breaks for her friends and family, Jessica Marks made her own choices that night. We have to look at the actions of Jessica Marks and ask ourselves, who called the shots? And while the plaintiff wants you to focus only on those 3 hours that she was at the bar, we also need to look at the choices she made before going to the bar. A choice to get a fake ID, a choice to drink, a choice to drive to Sonny's. We need to look at the choices she made during her time at the bar. A choice to continue to order more and more and more alcohol. And ask yourself if the plaintiff ever showed signs of obvious impairment to the defendant, because that's what's at issue here. We also need to look at the choices that she made after leaving that bar. After bragging about her ability to drive drunk, Jessica Marks turned the keys and, as you'll see, put herself and everyone else on the road at risk. Now, it is tragic what happened to Jessica Marks, but she was always in control. She called the shots. Find the defendant not liable. Thank you.
Thank you very much, defense counsel. All right, plaintiff. Once I get you on screen, there you are. Are
Yes,
you
Your
ready
Honor.
to present your case in chief?
Yes, Your Honor. At this time, we call Morgan Levin to the stand.
All right. I see Ms. Levin on screen. Thank you for being here. Ms. Levin, you are presumed sworn, and Ms. Morris-Beber, you may proceed whenever you're ready.
Yes, Your Honor. Good morning, Ms. Levin.
Good morning.
Could you please state your name for the court?
My name is Morgan Levin.
Do you know Jessica Marks?
Yes, I do. She was my best friend.
Where are the two of you from?
Well, we're from Pennsylvania.
Do you still live in Pennsylvania?
No, actually. After high school, I moved away to California and I go to UCLA now.
What about Miss Marks? Did she go to UCLA?
No, she decided to stay in Pennsylvania and she's going to Drexel University now, or was going to Drexel.
Did she ever visit you in Los Angeles?
Yes, she did for the week of spring break.
What dates was she coming to stay?
March 18th to March 28th.
And Miss Levin, how old were the two of you during that break?
We were both 19.
All right, let's talk a bit about one of those days, March 24th, 2019. What did the two of you do that night?
Well, I went to her Airbnb and we caught up and had 1 to 2 drinks.
And were those alcoholic drinks?
Yes, but we just had a glass of wine or two.
How much of that wine exactly did Miss Marks have?
I believe Jessica had 1 or 2 drinks of wine, 1 or 2 glasses.
What did you do after you were at Miss Marks's Airbnb?
Well, then we decided to go to Sonny's bar.
How did you get there?
Jessica drove us.
How did Miss Marks appear when you arrived at the bar?
She seemed to have a little bit of alcohol in her system at the time.
What symptoms was she presenting?
Well, her eyes were starting to be a little watery and red, and she smelled a little like alcohol, and she started to slur her speech and be a little louder than usual.
When was that?
That was at around 9 p.m. at night.
So once you got to the bar, did you order anything?
Yes, we did.
Who was serving you?
Sonny Maida was serving us.
How many times did you interact with Ms. Mehta that night?
Around 8 to 10 times she came to the table to take our orders.
How long were those interactions?
about 30 seconds to a minute each time.
What did Miss Mehta do at your table?
Well, she served us drinks and took our orders.
Did you ever observe her while she was not serving your table?
It's a pretty small bar, so yeah, we saw her walking around at several times of the night.
And Miss Levin, if you can recall, what did you order that night?
Well, we ordered a bottle of wine, some guacamole and chips. I believe we ordered some White Claws and 1 to 2 beers and 2 shots.
Over the course of that night, how much did you drink?
I drank a glass of wine, a beer, and 1 shot.
Did the two of you end up finishing the drinks you ordered?
I don't remember exactly which ones Jessica finished, but I believe she finished her drinks.
And Miss Levin, did you observe any more signs of intoxication over that night?
Yes, I did. She started to not make very much sense, and she...
Objection, Your Honor. 401, may I be heard?
Sure.
All right, Your Honor, could I get permission to put up the jury instructions?
Yes, that's fine. We're outside the presence of the jury constructively, so go ahead.
All right, so looking at these jury instructions, the standard here for obvious intoxication is that the symptoms Ms. Marks was displaying had to be displayed to Sunny Mehta. Any evidence of these symptoms being displayed outside of his presence, they aren't relevant. And until that foundation is laid, this line of this testimony is not relevant.
All right, response from the plaintiff?
Yes, Your Honor, we've already laid the foundation that Sunny Mehta was Ms. Marks's server that night, that she saw her 8 to 10 times over the course of 3 hours. Their interactions were 30 seconds to a minute, and Sunny Mehta was around the bar constantly. I'm simply asking Ms. Levin the symptoms Ms. Marks displayed that night. Specifically across that 3-hour period, it's reasonable that if Ms. Marks was exhibiting those symptoms, she would have been displaying them to Ms. Mehta.
Okay, thank you, both parties. So I'm going to overrule the objection. Ms. Hunnicutt, your objection is noted and well taken. I just want you to note that I think that's more of an issue of weight that you can take up on cross. You can absolutely, you're free to question this witness about the extent to which that she was behaving that way in the presence of an agent of the defendant's company. But I think insofar as that she was displaying these symptoms at the bar, that meets the threshold for relevance and at least raises the presumption that they had the opportunity to observe her that way. So if you want to question that, I encourage you to do it on cross. Well taken, we'll argue both parties. Thank you. It will be overruled. And Ms. Morris-Beber, you can continue.
Yes, Your Honor.
Ms. Levin, what symptoms of intoxication did you observe that night?
Well, as I was saying before, she started to not make very much sense, and she also fell at one point of the night.
What happened when she fell?
Well, we were trying to get to the restroom at around 10 p.m., and she fell down the stairs into Sunny Mehta, actually.
How did Ms. Mehta react?
Well, I think she said, maybe it's time to cut this one off, Frankfurt.
And just to be clear, Ms. Levin, what time did this happen?
This happened at 10 p.m.
I'd like to fast forward an hour, talk about something that happened a little later that night. Let the record reflect, I'm screen sharing what has been marked as Exhibit 10. Ms. Levin,
The record will still reflect. Oh, sorry, go ahead. Just noting it for the record, go ahead.
Ms. Levin, do you recognize this exhibit?
Yes, I do.
What is it?
This is a video that I took of Jessica at the bar.
When was it taken?
It was taken at around 11 o'clock.
And from what you can see, is it fair and accurate to the best of your knowledge?
Yes.
Your Honor, at this time, we offer Exhibit 10 into evidence.
All right, any objection?
Yes, Your Honor, I would actually object Rule 403. May I be heard?
Sure, go ahead.
Yes, Your Honor, as the plaintiff hasn't laid any foundation that Ms. Marks was served after this video, And since that's the standard for obvious intoxication, this video only serves to mislead the jury and confuse the issues.
Okay, I just want to clarify this before I hand it back to the plaintiff, because you're saying that it's unfairly prejudicial or it misleads the jury because there's no evidence that she was served after this video was taken?
Yes, Your Honor. It misleads the, yes, Your Honor.
Okay, can you expand on that a little bit more? I'm not exactly following you.
So, Your Honor, the jury instructions say that the standard for obvious intoxication is that Jessica Marks had to be displaying symptoms of intoxication before she was served. And since we don't know whether or not this video was taken before she was served, it merely confuses the issues.
I see. Okay, so it goes to the perceptions of the defendant and their agents is what you're saying, whether they actually saw this. Okay, all right. Ms. Morris-Beber, response?
Your Honor, for a piece of evidence to be more prejudicial than probative, it has to be highly misleading or highly inflammatory. This video is merely showing contemporaneous evidence of how Ms. Marks appeared at that time of night. And as an offer of proof, I will then ask Ms. Levin if she was served after she took this video. It's also highly probative, as I said, because it shows the symptoms Ms. Marks was displaying.
Okay, here's what I'm going to do. At this point, I don't think, and I reviewed the video and camera, so here's what I'm going to do. I'm going to overrule the objection, but pending that offer of proof that there will be questioning about the agents of the defendant's company observing her afterwards, as Ms. Morris-Beber just represented. So I will conditionally admit it with that understanding, and then it will be fully admitted once those follow-up questions are asked.
Yes, Your Honor.
Ms. Hunnicutt?
Yes, Your Honor.
Your problems? Okay, sounds good. It will be conditionally admitted with that understanding.
Ms. Levin, were you served after this video was taken?
I don't remember exactly, but I believe my drink might have been refilled.
Your Honor, permission to publish this exhibit for the jury?
Yes, no need to ask. That's fine. It will be shown to them.
Ms. Musselman, could you play the video?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Levin, is Ms. Marks's behavior in this video consistent with what you saw that night?
Yes, it is.
I'd now like to talk about what happened at the end of the night. When did the two of you leave the bar?
We left the bar at around 11:45.
How did you plan on getting home?
Well, I decided to take an Uber and also in the hopes that Jessica would take the Uber with me.
What did Ms. Marks end up doing?
She didn't want to leave her car and so she decided to go and take her car and drive herself home.
What happened after you saw herself drive herself home?
Well, I was in the Uber right behind her, and I was following her, and we didn't even make it. We barely made it away to the bar, and she drove off the highway into the ravine. And I asked them to pull over immediately, but it was too late.
Ms. Levin, I know this must be hard for you, but could you estimate about how far Ms. Marks made it?
Barely 1,000 feet.
Thank you, Ms. Levin. Nothing further at this time.
Thank you very much, Ms. Morris-Beber. Defense counsel, Ms. Hunnicutt, whenever you're ready, you can cross-examine.
Yes, Your Honor. Now, Ms. Levin, I want to start by seeing if there's something that we can agree upon. Before you left Ms. Marks's Airbnb, she had a glass of wine, correct?
Yes, she had a glass of wine.
She got in her car.
Yes.
She drove to Sonny's.
Yes.
And that was a choice she made, correct?
Yeah, you could say that.
She said, go big or go home.
Yeah, she was the life of the party.
Over the course of that night, she ordered several drinks.
Yes.
No one forced her to do that, correct?
No.
It was a choice that she made.
Objection, Your Honor, calls for speculation.
Okay, how so?
Your Honor, Ms. Hunnicutt is asking whether or not this was a choice Ms. Marks made. It's asking to speculate about the mindset of Ms. Marks that night, which she can't know as she's not Ms. Marks.
All right, response, defense?
Yes, Your Honor. Your Honor, this is not speculation, as I'm merely asking this witness what she saw and not asking her to testify as to the state of mind of Ms. Marks. If she saw Ms. Marks order a drink, then she can reasonably, based on her perception, that Ms. Marks made the choice to order that drink and no one forced her to do it.
I tend to agree. I think this is something she can testify based on her observations and her perception. So overruled.
Yes, Your Honor.
So Ms. Levin, ordering those drinks, that was a choice that she made, correct?
Yes.
And sadly, at the end of the night, she made the choice to drive.
Yes, but she was so drunk. I mean, she couldn't even speak straight at that time of night.
You actually tried to convince her not to drive, is that correct?
Yeah, I did.
But she said that she was good at driving after drinking.
Yeah, I should have done more.
Now, Ms. Levin, you haven't always been completely truthful throughout this process, is that correct?
Objection, Your Honor, argumentative.
Sustained, please rephrase that. Go ahead.
Yes, Your Honor. And now, Ms. Levin, you haven't always you haven't been completely truthful as you have been going throughout this process, is that correct?
Objection, Your Honor, argumentative.
I'll rephrase, Your Honor.
Counsel, go ahead. All right.
Right. A permission to display Exhibit 23.
Yes.
Your Honor, this document is pre-admitted. And now, Ms. Levin, after Jessica's accident, you spoke to the police, is that correct?
I believe I did, but I just can't remember that well.
And this here, it says that you told the police that you hadn't had anything to drink.
I thought we were going to get in trouble.
So what you're quoted as saying here, Ms. Levin, it's not true, is it?
Objection, Your Honor, argumentative.
I'm not going to sustain this one because this is now we've narrowed the scope of the question and defense counsel is being specific about what they believe the witness was, the instance in which the witness was being untruthful. So the witness is free to answer the question as they deem appropriate based on at least the way the question has been phrased in the context of time. So overruled.
Yes, Your Honor.
Yes, Your Honor. Right, so this says that after that, you told the police officer that you had each only had 3 drinks.
Yes, I did, but I still thought we were going to get in trouble. So.
And what you're quoted as saying there, that's not true either, is it?
No, it's not.
And when you were asked about how you got alcohol, you refused to answer, is that correct?
Yes, but I answered later on in my deposition.
And when you first refused to answer, that was because you knew that you had committed a crime.
Well, yes and no. I also just wasn't really in a good state of mind. I just watched my best friend die.
You'd been using a fake ID that night, correct?
Yes.
That week, you had used a fake ID to buy alcohol?
Objection, Your Honor, relevance.
Counsel, what's the relevance for her use of a fake ID earlier in the week?
Yes, Your Honor, by testifying, Ms. Levin has put her credibility in question. And Your Honor, under Rule 608B, we're allowed to delve into specific instances of conduct that could prove a character trait of untruthfulness.
All right, plaintiff, what's your response to counsel's use of Rule 608?
Your Honor, it's not my understanding that using a fake ID is a crime of dishonesty. Ms. Levin has not shown a dishonest act, and therefore counsel is using it for propensity purposes to show her negligence that week.
Okay, so here's what I'm gonna do. So 609 is the rule that requires it to be a conviction. 608 is on cross-examination, at least permits specific instances of conduct to be inquired into if they're probative of truthfulness. If the witness did in fact make this false statement on a specific instance, that is something that can be probed into, at least to allow the jury to assess their truthfulness or untruthfulness. So with that understanding, I'm going to overrule the objection, but we'll issue a limiting instruction to the jury not to take this for any kind of propensity for any one party's negligence. And with that, we will proceed. Thank you.
Yes,
both.
Yes, Your Honor. And now we talked about about Jessica's drinking on the night of March 24th, but you were drinking that night too, correct?
Yes, but I've never been much of a drinker. No, I only had a couple.
Is it possible that alcohol impacted your memory?
No, I don't believe so.
All right, well, you had a glass of wine at the Airbnb, is that correct?
Yes.
You had another glass of wine at the bar?
Yes.
You had a shot at the bar?
Yes.
You remember having one beer that night?
Yes.
You might have even had another beer.
Possibly, but I don't think so.
That's right. You don't remember, do you?
Oh, well, it was over a year ago, but yes, there are certain things that I don't remember.
Right, Your Honor, let the record reflect we're now displaying what's previously been marked as Exhibit 17. Let's look at that receipt again. So look at the tip. You're the one who did the math here, correct?
Yes, I did.
Those numbers...
Objection lacks foundation.
What's missing, counsel? How so?
Your Honor, there's been no foundation laid that this is an accurate copy of this exhibit. It hasn't been entered into evidence.
Okay, well, I'm gonna let counsel, before they offer it and show it, actually, well, sure. Okay, counsel, why don't you ask those questions before we get into the specifics and ask about that? Why don't we have the witness identify this first?
Yes, Your Honor.
Sustained us to that point, yeah.
So Ms. Levin, do you recognize this receipt?
Yes, I do.
And from what you can tell, it's a fair and accurate copy?
Yes.
Right, so looking at the tip, you're the one that did the math, is that correct?
Yes, I did.
The numbers there, they don't add up, do they?
No, they don't.
And now, in your experience, would you say that alcohol can sometimes impact your memory?
Sometimes, yes.
All right, so you showed us some pictures earlier. There were actually 6 other pictures here that you deleted, correct?
Yes.
But you don't remember deleting them?
No, but I probably deleted them because they were blurry or fuzzy.
You don't remember what was in those deleted photos, correct?
No, not specifically.
You talked earlier about the symptoms of intoxication that Jessica showed, but you don't remember a single specific time when Jessica acted intoxicated in front of Sunny Mehta, is that correct?
No, but Sunny visited us all throughout the night. So she must have saw.
All right, we saw that video earlier. When you were deposed, you didn't mention a single instance where the bar served Jessica at any point after that video, correct?
No, I said I don't remember.
Right. Thank you, Ms. Levin. Your Honor, at this time, I have no further questions.
Thank you very much, Ms. Hunnicutt. Redirect examination?
No redirect from the plaintiff, Your Honor. May this witness please be excused.
Yes, Ms. Levin, thank you for your testimony. You may step down.
And at this time, Your Honor, the plaintiff rests.
All right, thank you very much, Ms. Morris-Beber. Ms. Hunnicutt, anything before we proceed with your case in chief?
No, Your Honor.
All right, you can go ahead and call your witness whenever you're ready.
Right, the defense calls Sunny Mehta to the stand.
All right, Sunny Mehta is on screen. I want to make sure we get plaintiff counsel back as well before we start. There we go. All right, great. Ms. Mehta, you are presumed sworn, and Ms. Hunnicutt, you can proceed whenever you're ready.
Yes, Your Honor. Could you please introduce yourself?
Sure thing. My name's Sunny Mehta. I'm 27 years old.
All right, tell us a little bit about yourself.
Of course. I grew up in Texas and moved out to Los Angeles to open Sonny's Rooftop Bar. I ran it for 2 years.
I want to talk a little bit more about Sonny's Rooftop Bar. I'll let the record reflect that I'm now displaying exhibits 8 and 9. What are these, Ms. Mehta?
These are photos of my bar. You see, exhibit 8 is a rooftop and exhibit 9 shows the inside of my bar.
All right, using these pictures, can you describe the layout of your bar?
Sure. At the top, at the rooftop, we have about 24 tables, and that's where we go and deliver our drinks. And inside the bar is where we make and take orders of the drinks.
Do you remember seeing Miss Levin and Miss Marks on March 24th of 2019?
Yes, I do, ma'am.
What time did you first see them?
When they enter my bar, so 9 p.m. around.
At that time, who was working at the bar?
It was just me and another bartender. His name is Frankfurt Johnson. I'm pretty loud on Sundays.
Mr. Robertson, could you put up exhibits 8 and 9 again? Using these pictures, where was Mr. Johnson that night?
He was downstairs, so exhibit 9, making all the drink orders.
And where were you?
I was going back and forth from the inside of the bar and up top on the rooftop.
Could you tell us where Jessica Marks and Morgan Levin were?
Yes, ma'am. They were on the rooftop at the lower right-hand corner of exhibit 8. You see the chair with the blue cushions is where Miss Morgan was sitting, and Miss Marks's chair was off to the right of this photo.
All right, Mr. Robertson, you can take those exhibits down now. All right, over the course of that night, who served Miss Marks's table?
I did, ma'am.
How many times did you serve Miss Marks?
Between taking orders and delivering their drinks, I'd say around 8 to 10 times.
And how much time would you spend at their table each time?
Nothing more than 30 seconds to a minute.
While you were interacting with Miss Marks, what, if any, signs of intoxication did you see?
Ma'am, I saw none. Miss Marks looked fine, and no signs of intoxication whatsoever were present.
What about Miss Levin?
Miss Levin was a different story. Now, she looked kind of buzzed, a little tipsy. Her eyes were kind of red and she was tripping over her words, but it was nothing too serious or too drastic where I had to cut her off.
Let the record reflect I'm now displaying exhibit 17. So from this exhibit, what, if anything, can you tell us about the order in which the drinks were ordered?
Well, you see, our system at Sonny's Rooftop Bar lists the drinks in the order in which they're ordered, except if one customer orders the same round of a drink, multiple rounds. So we know that they started off with the bottle of wine and then they had the chips and guac, but we don't know whether their second orders of chips and guac were before the beers.
Does this receipt give any indication as to the time that you stopped serving Miss Marks?
No, ma'am, just when they closed the tap.
Do you remember when you stopped serving Miss Marks?
No, ma'am, I don't remember.
All right, I want to look at some pictures to see if we can get an idea of when. So looking at exhibits 11 through 16, who is that in the background?
Based off the clothing, I believe it's Miss Marks.
And who is sitting in the seat from the vantage point of the camera?
Miss Levin.
Let's look at Miss Marks's side of that table. On which of the pictures do you see the last new drink added to Miss Marks's side of the table?
Well, I see in exhibit 14 off the left of Miss Marks's table, you got an IPA draft beer.
Your Honor, at this time, I'd like to read into the record a portion of stipulation 16.
That's fine, go ahead.
It says, based on metadata from Morgan Levin's phone, exhibit 13 was taken at 9:42 p.m. and exhibit 14 was taken at 10:18 p.m. Right now, Miss Levin, Miss Mehta, we heard today that Miss Levin said that at one point Miss Marks bumped into you. Is that true?
No, ma'am. I would have remembered if anyone bumped into me that night.
We also heard Miss Levin claim that you said you needed to cut Miss Marks off. Did that happen?
No, ma'am. Absolutely not.
At any point that night while you were serving Miss Marks, did Miss Marks ever appear drunk to you?
No. If she looked drunk or showed any signs, I would have cut her off.
Thank you, Miss Mehta. Your Honor, at this time, I have no further questions.
Thank you very much, Ms. Hunnicutt. Ms. Morris-Beber, cross-examination?
Yes, Your Honor.
Go ahead whenever you're ready.
Good morning, Ms. Mehta.
Good morning.
I'd like to talk about a previous incident at your bar. Let the record reflect, I'm showing the witness what has been pre-admitted as Exhibit 1. This is a copy of a plea agreement you made from 2018. Is that right?
Objection, Your Honor. 404, may I be heard?
Go ahead.
Your Honor, they're trying to use this exhibit to prove a character trait in Miss Mehta, which isn't admissible under Rule 404.
All right. Response.
Yes, Your Honor. Exhibit 1 has been pre-admitted, so it's already part of the record. I'm merely asking Ms. Mehta questions about what is in this exhibit.
Yeah, that's my understanding too. So at least as to the content of this, that can be discussed and admitted. And my understanding of this is not that it's a character trait of Ms. Mehta in her personal and individual capacity, but the defendant, in this case, Sunny's rooftop bar, as at least a prior plea deal. So with that understanding and within the limits of this document and its contents, I'm going to overrule the objection.
Yes, Your Honor.
Ms. Mehta, this is a copy of a plea agreement you made in 2018. Is that right?
That's correct.
Because your bar served a minor alcohol. Is that correct?
Yes. Fortunately, but it was an accident.
That minor fell down the stairs of your bar.
Yes, he did.
Broke his leg.
That's true.
And the bartender who served him was Frankfurt Johnson, right?
Yes, ma'am.
And just to be clear, Ms. Mehta, Frankfurt Johnson was working the night of March 24th, wasn't he?
Yes, but he was just making drink orders. He wasn't serving anyone, taking orders.
And Frankfurt Johnson is a co-defendant in today's case?
That's correct, ma'am.
And Ms. Mehta, you paid a $250 fine, didn't you?
Yes.
You also kept your liquor license.
Yes. We vowed to become better and not serve anyone who's underage. So we ordered ID scanners.
Let's talk about March 24th, 2019. You were working that night, weren't you?
I was.
As a server?
Yes, ma'am.
You saw Jessica Marks that night?
I did.
You saw her walk in?
She walked in and looked fine.
She came in with Morgan Levin?
Yes, ma'am.
That was at 9 o'clock.
I remember around that time, yeah.
At that time, to you, she seemed fairly sober, right?
Yes, ma'am. Very normal.
And Miss Mehta, you also served her that night, didn't you?
I did, ma'am.
You took her drink orders?
Yes.
You brought drinks?
Yes, ma'am. Delivered drinks?
Cleared her table?
Yes, ma'am.
So in total, you saw her around 8 to 10 times that night.
That's correct, ma'am.
You also are aware of what she ordered, aren't you?
Yes.
You normally create receipts for your customers?
Every time they order, yes, ma'am.
You created one for Miss Marks and Miss Levin?
Of course, regular practice in my business.
Your Honor, let the record reflect I'm showing the witness what has been marked as Exhibit 17. This is the receipt you made that night?
I did, ma'am. Yes.
It's fair and accurate to the best of your knowledge?
Yes.
Your Honor, at this time, we offer Exhibit 17 into evidence.
All right, any objections?
I have no objection, Your Honor.
All right, it will be admitted and received.
So, Ms. Mehta, let's walk through the drinks Ms. Marks and her friend ordered that night. They ordered a bottle of wine.
They did, ma'am, yes.
They ordered 3 cans of White Claw.
Yes, ma'am, I remember.
That's a hard seltzer.
It is quite popular among my customers. I don't know why, though.
They had a draft beer.
Yes,
They had a can of beer.
they did.
They had green tea shots.
Yeah, ma'am,
And those contain whiskey, don't they?
they do.
All right, I'd like to talk a little bit about those photos you saw on direct examination. Let the record reflect I'm screen sharing what has been marked as Exhibit 15. You see the beer can in the back is empty, right?
Yes, ma'am.
I'm screen sharing what has been marked as Exhibit 16. In this photo, the glass of beer is full, isn't it?
It is, ma'am, yes.
This is the last photo that was taken that night.
To my recollection, I believe so, based off of what I saw.
And Ms. Mehta, you also saw Ms. Marks leave your bar, didn't you?
I did. She looked fine.
She appeared almost sober.
Yeah, she looked fine.
Ms. Mehta, I'm screen sharing what has been marked as Exhibit 22. What has been pre-admitted as Exhibit 22. To your knowledge, this is a copy of Jessica Marks's autopsy report.
Yes, ma'am, it appears so.
And it says that her blood alcohol content taken moments after the crash was 0.16.
That's what it says, yes, ma'am.
You are aware, Ms. Mehta, that the legal limit for alcohol for adults is 0.08?
I am aware. I learned that with my responsible beverage service course.
Thank you, Ms. Mehta. Nothing further at this time.
Thank you, Ms. Morris-Beber. Ms. Hunnicutt, any redirect examination?
I have no redirect, Your Honor.
All right. Thank you very much for your testimony, Ms. Mehta. You may be excused. And with that, anything further from the defense?
No, Your Honor, at this time, the defense rests.
All right, thank you. Evidence is closed. Both parties have rested. And Ms. Morris-Beber, once you're back on screen, we'll proceed to closing arguments. Just want to make sure I get both parties again.
Yes, Your Honor, I'm ready to give my
All right, sounds good. All right, you can proceed whenever you're ready.
We all have responsibilities. We have responsibilities as employees, as parents, as citizens, and when we fail in those responsibilities, we face the consequences. Serving alcohol comes with special responsibility because lives get upended. People get injured, mothers lose their daughters. And when Sunny Mehta failed in her responsibility to stop serving drunk customers, Jessica Marks died. So now Sunny Mehta must face the consequences. I told you in my opening, the plaintiff must prove 2 things: that Jessica Marks was obviously intoxicated when served alcohol, and that over-serving of alcohol was a substantial factor in her car crash. And I have proven both elements more likely than not. But before I dive further into the evidence we heard today, it's important to remember that this has happened before. A minor has been served alcohol at Sunny's before. A minor broke his leg coming down the stairs at Sunny's bar. We saw the plea agreement where Sunny Mehta pled guilty. We saw the bartender who forgot to check that miner's ID was Frankfurt Johnson, Sunny Meta's other employee who was working that night. The person Sunny Meta kept on, and the person who is a co-defendant in today's case. We also saw Sunny Meta learned nothing, because Miss Meta paid a $250 fine. She kept her liquor license. We saw that Sunny Meta faced no consequences. So members of the jury, I'd like you to remember, when Miss Hunnicutt comes up in a minute and tries to tell you about what Sunny Meta didn't see, couldn't have seen, this has happened before. And Sunny Meta knew better than to let it happen again. So let's talk about that first element, obvious intoxication. Because Jessica Marks was obviously intoxicated that night. And the symptoms of obvious intoxication, you members of the jury may consider, include loss of motor coordination, bloodshot eyes, flushed cheeks, loud conduct, slurred speech, and rambling. But obvious intoxication really comes down to what a reasonable person would perceive as drunk. We heard the testimony of Morgan Levin, who was with Jessica Marks that night, that Ms. Marks had red, watery eyes, that she smelled like alcohol, that she slurred her words, that she rambled, that she almost fell into the bar owner, Sunny Meta. So members of the jury, we know Sunny Meta knew. We know Sunny Meta knew Jessica Marks was obviously intoxicated. We know that happened at 10 o'clock that night, so we know Sunny Meta kept serving her drinks, to the point where Morgan Levin didn't want to get into a car with Miss Marks. But Miss Hunnicutt will come up in a minute and tell us you can't trust Morgan Levin, because Morgan Levin was drunk that night, because she lied to a police officer only moments after her friend died. So members of the jury, let's not just take Morgan Levin's word for it, because we saw a video of Ms. Marks's behavior taken at around 11 o'clock that night. We saw her slurring her words. We saw her rambling. We saw her incoherent. We saw her being loud. We saw her lack of motor coordination as she failed to grab her drink. Members of the jury, we heard that Sunny Meta served her even after that. We saw the image from that night taken at around 11 o'clock where there's a glass that was empty. And then the next photo where that glass is suddenly full. We know they were served. And I ask you, anybody who has seen that video, who would not perceive Ms. Marks was obviously intoxicated? What reasonable person would continue to serve her alcohol? So let's move to that next key element. The bar over serving Ms. Marks was a substantial factor in her crash. Members of the jury, there's one obvious answer. One answer supported by the evidence. We saw Ms. Levin's receipt from that night, showing the drinks the two ordered. We saw the bottle of wine, the 3 White Claws, the 2 beers, the 2 shots. We saw Ms. Marks's blood alcohol content. We saw that it was 0.16 moments after the crash, that it was twice the legal limit. Members of the jury, let's use our common sense here. There's one answer that makes sense, and it's that Sunny Meta serving Ms. Marks alcohol caused her car crash. Members of the jury, let's make sure this never happens again. Let's make sure bars serve alcohol responsibly. Let's make sure there are no more stories like Jessica Marks's, where teenage girl ends up dead in a ravine because a bartender couldn't take the responsibility to cut her off. That night, Sunny Mehta had the responsibility, so now she must face the consequences. Please find Sunny's Rooftop Bar liable for Jessica Marks's death. Thank you.
Thank you very much, Ms. Morris-Beber. Ms. Hunnicutt, when you're back on screen, there you are, you can proceed whenever you're ready to go.
Yes, Your Honor. Who called the shots? In lawsuits, we often ask ourselves the question, who is in the best possible position to prevent the harm? And in this case, time and time and time again, Jessica Marks had a choice. And time and time and time again, she made the wrong one. Now, first, I want to start with the plaintiff's claim. And keep in mind, the plaintiff's claim is not negligence. It's not about whether they should have taken Miss Marks's keys after she walked out the door. It's not about whether Miss Marks was intoxicated after she left the bar. No, the plaintiff's claim, it's based on the Dram Shop Act. And what the Dram Shop Act does is it holds bars liable if they overserve alcohol to a minor while that minor is obviously intoxicated, and doing so proximately causes injury. But here's the thing, the standard there is not whether they served someone who later became intoxicated. No, let's take a look at the jury instructions. So first, the symptoms have to be displayed to the defendant, not outside the defendant's presence. And second, the symptoms have to be displayed before the alcohol is provided. Look at that word, before. Not hours later, not minutes later, not seconds later, before the alcohol is provided. Now think about this. As Miss Marks drank more and more alcohol that night, her impairment level would go up. And the sharpest increase would have been when she drank the green tea shot. But the standard isn't how she was acting after she drank that green tea shot. It's how she was acting in front of Sunny Mehta before she was served her last drink. And I want you to ask yourselves, has the plaintiff even proven when that was? Fortunately, looking at these pictures, we can recreate the timeline. So the last new drink that you can see in these pictures is in Exhibit 14, taken at 10:18 p.m. Now, why is that significant? It's before the evidence that they contend showed Miss Marks's intoxication, before she allegedly fell down the stairs at 10 p.m., before the video recording at 11:11 p.m. And Mr. Robertson, could you bring up Exhibits 15 and 16? All right, so my opposing counsel, she tried to tell you that they served Jessica Marks after the video at 11:11 p.m., but that's simply not true. She tried to tell you that the last drink that they were served was that beer in front of Morgan. What matters here is what Jessica was served. Morgan was the one who was served that beer, so the last drink that Jessica was served was not that beer, as my opposing counsel would have you believe. And speaking of the video at 11:11 p.m., the plaintiff, they can play that video all they want. Do you see Sunny Mehta in it? No. So does that prove that Miss Marks was acting intoxicated in front of Sunny Mehta? Of course not. And more than that, and I can't emphasize this enough, they haven't proven to you that Miss Marks was served after that video. Now, my opposing counsel got up here and she told you that they were served after that. But I want you to think back to the direct examination of Morgan Levin when she asked her if they were served, and Miss Levin said, "I believe my drink was refilled." Not Miss Marks. Morgan Levin admitted that she was served more alcohol that night, but not Miss Marks. There's no evidence that Miss Marks was served after that video was taken. At the end of the day, what is the plaintiff's proof? Someone else's bar tab? The testimony of a friend who had to admit to lying to the police? But put that aside. Let's assume that what Levin is saying is true, because even so, She couldn't name a single specific instance whenever she saw Jessica acting intoxicated in front of Sunny Mehta. And as the judge will tell you, even if you do find for the plaintiff on their claim, you still have to look at Jessica Marks's own conduct. This is something that Ms. Morris-Beber didn't seem to talk enough about. We as the defense have asserted an affirmative defense of comparative negligence, which means we want you to ask yourselves the question, did Jessica Marks's own conduct play a part in causing her death? And to be clear, her actions don't even have to be the only factor. Now, before I get into this, I don't want to seem cold. It is tragic. A 19-year-old girl gone way too soon. It's easy to let those emotions overcome your judgment. I mean, it's difficult for me too. But the law says that our emotions can't animate our decisions. We have to look at the facts. And what did the facts show us? Even before going to Sunny's rooftop bar, Miss Marks drank at least one glass of wine, maybe more. Miss Marks got in her car and drove to Sunny's. She didn't have to. She called the shots. Miss Marks brought with her to that bar a fake ID. And when she got there, she ordered round after round after round. No one forced her to drink. She called the shots. And most tragically, when she left, Miss Marks had the chance to get in an Uber. She didn't. Her friend urged her not to drive that night, but Miss Marks ignored her. What did she do? She joked that she's good at driving drunk. If negligence is consciously disregarding a known risk, how can that not be negligent? In our court system, we put the responsibility for deciding truth, that's what the word verdict means. We put that responsibility in your hands. Find the defendant not liable. Thank you.
Thank you very much. Plaintiff, rebuttal?
Yes, Your Honor.
Go ahead whenever you're ready.
We make these laws to stop teenagers from making bad decisions. We make these laws for people like Sunny Mehta to follow them. Ms. Hunnicutt has asked us who called the shots. Sunny Mehta did. Sunny Mehta called the shots. Sunny Mehta had the responsibility. So please find her liable. Thank you.
Thank you very much. And thank you both parties. The matter is submitted. And with that, let's make sure we confirm with our bailiff. But it looks like at this point, what we're going to do is just take a couple minutes to finish filling out our score sheets, and then we will come back on screen, give really brief comments, and then get you on forward from here. So I guess just a couple minutes. Thank you.